the EU palm oil from Malaysia case. Full title of this case: European Union and certain member states, EU member states, certain measures concerning palm oil and oil palm crop-based biofuels. Complainant, Malaysia, the second largest producer of palm oil. Respondents, the European Union, France and Lithuania. Because whereas in this case we will only focus on the European Union and the claims brought against the European Union's measures, there were also a few French measures that were challenged by Malaysia. We will not be talking about this. Not because these measures are not interesting, they are interesting, but we have to make choices. Malaysia also brought a case against Lithuania. And this was because Lithuania implemented the European legislation in its domestic legislation. And therefore Malaysia thought that since Lithuania, which is a European Union member state, but also a full-fledged WTO member, the fact that Lithuania implemented legislation of which Malaysia argued that it was WTO inconsistent, and that meant that Lithuania itself was also inconsistent with WTO law. There was very little specificity to the arguments of Malaysia in that respect. It was just, Lithuania, you have implemented EU legislation, which we considered to be WTO inconsistent, therefore you also violated WTO law. I can tell you that on that point, the panel didn't really engage. Yeah? They threw that out in a very short paragraph. I think this is going to in other cases, because personally, I think that Lithuania should also have been found to, or at least that examination should have been done, should not have been thrown out as it did. But this will be for another case. This case was so long, so complicated that I understand on the side of the panel that they said, listen, let's move on. We will also not talk about the French measures. Third parties, 24 third parties in this case, including US, China, India, Indonesia, so the whole, a lot of third parties. Now, there's a note that I need to make here on the EU palm oil from Indonesia case. Indonesia actually challenged measures at issue in the case that we are about to discuss. They challenged it first. And Malaysia challenged the same measures months later, really months later. Now you'd say, so why didn't you focus on the EU palm oil Indonesia case? Well, the panel proceedings in that case had been suspended at the request of Indonesia, which is the right of any WTO member that brings a case. The complainant can request the suspension of that case. They had, shortly after the panel report had been issued to the parties, so the report was already known to the parties, but it had not yet been circulated. Shortly after the report had been issued to the parties, Indonesia requested the panel to suspend its proceedings. And that suspension, that ran up until Friday last week. The report in this case, which is pretty much identical, certainly on the points that we are going to discuss, pretty much identical to the report in the Malaysia case, came out, was circulated. But as long as that report was not there, I couldn't take it part of the discussion because it was not published. So that's why I'm talking about the EU palm oil from Malaysia case. But when you listen to me when talking about that case, know that the same is said in the EU palm oil from Indonesia case, or that came out just days ago. Now, why did Indonesia suspend panel proceeding? The rumor has been that they might have done something similar to what India did with the United States. Because Indonesia and the European Union have a number of disputes. Some disputes in which Indonesia is the complainant and the European Union the respondent, and vice versa. A number of disputes. And there was some rumor that certainly in the context of ongoing negotiations about a regional trade agreement between Indonesia and the European Union, that when these negotiations would come to a successful conclusion, all the disputes would be sort of wiped out. Well, whatever the motivation of the suspension was, the report is now public and will go to the DSB, where Indonesia theoretically may decide to appeal into the void, but we'll have to see. We'll have to wait until the next DSB meeting to see what's happening on this. The timeline, and now I'm back to the case that we're going to discuss, the EU palm oil case. Timeline, the request for consultation in this case came in January 2021. So that's months after there was actually already a request for consultation on the same subject matter by Indonesia. The panel was established in May 2021, and the panel had exactly the same panelists on it as in the Indonesia case. The panel report came out in March 2024. You can see that it took this panel a very long time to come out with its report. What is it? 3 years. 3 years to work on this report. It was a very complex matter. I'll tell you that. And the complexity of the case will become even more clear to you when we go to the list of claims of inconsistency made. The report was adopted on the 24th, on the 26th of April 2024. Now, let's say, well, why did the loser not appeal into the void? That's interesting, because Malaysia lost the case, but not on everything. Yeah. The panel did at the end identify one shortcoming. At least we will discuss one shortcoming. They identified two shortcomings, two mistakes of the European Union. We will not be discussing the other one. They identified one shortcoming, something that the European Union will have to do. And as I will explain when we get there, when the European Union changes its legislation, does what it's now supposed to do, outcome of this case may be very different. But we'll come there. So I think that Malaysia, while losing the case, because most of the measures at issue were not found to be WTO inconsistent, so the panel sided with the majority of the panel. It's a dissent here again. Majority of the panel sided with the European Union. While they did that, I think Malaysia has the hope that when the European Union modifies its current system, that the outcome may be more positive for Malaysia. So that's the only reason why I can understand why they did not appeal it to the void. Yeah. Because they want to see the European Union now make the changes that the panel asked them to make. The EU measures at issue are specific measures, and I would almost ask you to underline specific measures set out in. So it's not the whole RED II, it's not the whole EU Renewable Energy Directive of 2018. It's not the whole directive that was an issue in this appeal. It's merely specific measures. Now, the European Union made an attempt in this case to make the panel believe that the measure at issue was the whole system of renewable energy promotion. Malaysia again and again insisted, no, we're not complaining about the RED II as a whole. We're complaining about specific measures, which I will describe in a moment. The RED II, so the EU Renewable Energy Directive, and a delegated regulation of, a Commission delegated regulation of 2019. The directive itself was an act by the Council and Parliament, European Parliament. It's delegated regulation by the Commission. Now, the RED II, first telling you something about the whole system. Again, it was not the whole system that was challenged by Malaysia, but the RED II requires that by 2030, minimum 32% of energy used in the European Union would be renewable. Yeah. Would be from renewable sources. And that's for all energy. And for energy used in the transport sector, the ambitions were much lower, namely 14% of energy used in the transport sector would be from renewable resources. Now, those of you who remember my lecture yesterday will remember that one of the major sources of, the major source actually, of greenhouse gas emissions is transportation. But it's energy used in transportation is more difficult. It's more difficult to replace with wind and solar. Yeah. Of course, you can work with batteries, but actually for heavy transport, that is still very, very difficult. Lorries on electrical lorries are a rarity. Anyway, so the ambition under the RED is that by 2030, 14% of the energy used in transport has to be from renewable resources. Now, which are the specific measures that were challenged by Malaysia? The first specific measure, which we refer to as the 7% max, is that of these 14%, so of these 40%, only 7% of the 14 may be from biofuels made from food or feed crops. The rest, yeah. So the 93% in these 14% have to come from biofuels made from other materials, waste, or well, whatever is not food and feed crops, or has to come from solar. you talk about electrical vehicles. Or it has to come from, but not from, so only a very limited amount of renewable energy may come from, or may be constituted by biofuels from food and feed crops. That's the first measure, 7% max. And you can immediately see how this affects countries such as Malaysia, the second largest producer and exporter of biofuels, of palm oil, and Indonesia, the largest exporter of palm oil. Palm oil is a food crop, and from that biofuels is made, but it can only be 7%. The other measure that is at issue is that, okay, you get that 40% target, that 40% of the energy used in the transport sector has to be renewable energy from renewable sources. Got this 14%. Now, contributions to reaching this 14% made by what is called high ILUC risk biofuels. That contribution made by these biofuels is capped at the 2019 level and subsequently phased out. And at 2030, there will be, in those 14%, there can be no biofuels anymore that come from high ILUC risk, that are high ILUC risk biofuels. Now, the question that you should be asking yourself now is, ILUC, what is ILUC? ILUC is indirect land use change, ILUC. What on earth is indirect land use change? Well, it's easier to understand it if you go to the other concept of DLUC, direct land use change. Direct land use change is very easy to understand. Yeah, you have a piece of forest, and you cut the trees in that forest, and you plant palm palms, palm trees, and you plant them there. Then you remove direct land use change. Indirect land use change is that you don't plant the palm trees in forests, what used to be forests, but you plant it in what was agricultural land. Land where rice or wheat or corn used to be planted. But where do you think, because the demand for that rice, wheat and corn, that demand remains, where do you think that goes? That goes then to land that was forest. So that is indirect land use change. And there's a lot of discussion as whether that is something you can really observe, whether you can calculate, you can quantify that, whether you can even observe it. And Malaysia and Indonesia, in the case, argued, you can't even see it, you can't quantify it. And yet, that is going to be a determinative factor, because what does it say here? It says, when you have a biofuel that has a high ILUC risk, it will not, you can't take it into account anymore, these biofuels, to reach the 40% target of the European Union. Now, you'd say, put it here between brackets, but it doesn't refer to directly, it doesn't refer to palm oil-based biofuel. And the product in which Malaysia is interested doesn't reflect, it reflects to, and it caps and gradually phases out the use of high ILUC risk biofuels. But the system that the European Union had created made that the only biofuel that was considered to be high ILUC risk was biofuel that was made with palm oil. Palm oil-based biofuel was the only one that was considered to be high ILUC risk. And what was not considered high ILUC risk was biofuel made from rapeseed or soybeans. Rapeseed and soybeans are agricultural products that are produced in the European Union itself. You see the problem? You see the discrimination coming up? So the whole system that was set up was geared at identifying palm oil-based biofuel, without this being explicitly mentioned in the Red 2. The Red 2 does not talk about palm oil as such, but it talks about high ILUC risk biofuels, way in which the European Union defines what that is. It comes down to only one category, palm oil-based biofuels. And it excludes from this limitation, this cap and gradually phasing out, it excludes these biofuels that are made from products, rapeseed and soybeans that are produced in the European Union itself. To show you, the European Union does not use palm oil. It's not warm enough in the European Union. Right. Okay. There's a third measure, but that's a measure that we will not discuss. There was, as part of the Red 2, there is also a low ILUC risk certification procedure, which we will not discuss because it brings us into too much detail. Now, what have been the claims of inconsistency of Indonesia? This and this. So, talking about the complexity of a case, why did it take 3 years for the panel to come to grips with this? Also answering a question that, if I may say, law firms, what do they advise government to bring in terms of the claims? Well, I know for this law firm, because I was of counsel to it, you see what they argue. They argue everything under the sun. Go through it, and there is not a TBT agreement provision that is missing. Up to here, it's the technical regulation, and then after that, it's primarily the conformity assessment procedure, which is basically related to this third claim. It's a conformity assessment procedure. And then not only under the TBT agreement, but also under the GATT. And the panel report, as it should have, has both reasoning under the TBT agreement and then in parallel under the GATT. Why? Because it did not find an inconsistency with the TBT agreement. Small correction there, but not basically an inconsistency. And then you have to look whether there might be an inconsistency under the GATT. That's what the appellate body had said before. That it's not because this agreement has been dealt with under the TBT agreement that you don't have to look at the GATT. Now, of course, if you find an inconsistency with the TBT agreement, you can say judicial economy. The beast is dead. The beast cannot be deader than that. The beast has been found inconsistent with the TBT agreement, and if that's a TBT agreement that is parallel to one of the provisions of the GATT, then you don't have to go and examine the GATT. But in this case, the panel came to the conclusion that there was no basic violation of the TBT agreement, so it also looked at the GATT. Now, again, in order to finish on time, we'll not talk about the GATT provisions. We'll do some more of that tomorrow when we talk about two cases that one is still pending, the other is not yet brought to dispute settlement. The claims that we will discuss, you'll probably be very happy to hear that, is claims under Article 1.1, claims under Article 2.1, 2.2, and 2.4 of the TBT. The relevant provisions. Well, if we're going to focus on the TBT agreement, the first thing that we have to do is to answer the question, is this a TBT measure? Because if it's not a TBT measure, the TBT agreement does not apply. Where do we find the definition of TBT, of what a TBT measure is, and in particular, what the kind of TBT measure is that we're interested in? There are three kinds of TBT measures: the technical regulations, standards, and conformity assessment procedures. Now, we are interested in whether the measure at issue is a technical regulation. And the European Union said, no, this is not a technical regulation. See what the panel says. When is a measure a technical regulation? Well, the Annex 1.1 says it's a technical regulation when it's a document which lays down product characteristics or their related processes and production methods with which compliance is mandatory. By the way, the distinction between a technical regulation and a standard. Compliance with that is not mandatory. For the rest, technical regulation and standard are the same. Yeah? But that's just an aside. So that's not really relevant for this. But that's the definition of a technical regulation. Just now talking about relevant provisions. See what the panel did with this later. Article 2.1 of the TBT agreement. Article 2.1 sets out the non-discrimination obligations in the context of the TBT agreement. So here we have a provision that talks both about the national treatment obligation and the most favored nation treatment obligation. So in a way, if you look in GATT terms, Article 1 and Article 3 are combined in this provision of non-discrimination. And it reads as follows. Members shall ensure that with respect to technical regulations, products imported from the territory of any member shall be accorded treatment no less favorable than that accorded to like products of national origin and to like products originating in any country. So in the last bit, you could see that it's both national treatment and most favored nation treatment. Right. And you see language that will be familiar to most of you, treatment no less favorable. That is the basic concept that you also have for non-discrimination under the GATT. Article 2.2 of the TBT agreement. Article 2.2 of the TBT agreement actually is about the fact that technical regulations should not constitute unnecessary obstacles to trade. And that's also what you find in the title of 2.2 and in the first sentence. That's not very helpful. Yeah? So we're lucky that Article 2.2 goes on. And in the second sentence, and that's what I'm quoting here, in the second sentence, it says, technical regulations shall not be more trade restrictive than necessary to fulfill a legitimate objectives, taking into account the risks non-fulfillment would create. Period. Such legitimate objectives are, inter alia, protection of human health or safety, animal or plant life or health or the environment. Support from Article 2.2. interesting, perhaps I won't have the chance to repeat this later, but interesting is that it says here inter alia. Legitimate objectives are inter alia. If you think back of Article 20, what you know about Article 20, Article 20 has an exhaustive list of legitimate objectives, an exhaustive list of interests and values that can be promoted, protected. Here it says inter alia, which indicates that it's not an exhaustive list. Now, in this particular case, we don't really need that, because I think it's enough when it says explicitly that it refers to the protection of the environment. That will suffice for our purposes. But it's perhaps useful for you to keep in mind for future cases that things which are not part of Article 20, the list of Article 20, you can sort of integrate it here. Now, last provision that we need to look at today, I feel happy that we don't have to look at all the provisions that were invoked, is Article 2.4, 2 paragraph 4. 2 paragraph 4 is about the following. I won't read it out. I'll tell you about it. It's about, there are of course often international standards that have been agreed by international standard setting organizations on all sorts of things. Yeah. If such an international standard exists, or if it exists, and of course, if it's relevant to the subject matter that you're looking at, then the expectation is that members shall use these international standards as a basis for their technical regulations. That doesn't mean that they have to copy-paste the international standard. They have to use the international standard as a basis, meaning that they cannot go against the national standard. They cannot deviate from the national, but it's not a copy-paste. Yeah. So there may be differences, but you can't go against it. Except when that international standard is ineffective or inappropriate. Now, this is an important point for developing countries, because many of these international standards have been adopted quite some time ago, and they have been adopted at a time that developing countries were much less active in the relevant international standard setting organizations. That's one point. The second point is related to that one point, namely that when deciding on standards for international standards for products, they often do not reflect the particular climatological and other circumstances of developing countries. So developing countries can quite frequently, in my mind, argue that the international standard agreed so many years ago by mainly developed countries is not really appropriate or effective to fulfill their legitimate objectives. That's one thing. The other thing is, and that relates not so much to the fact that the standards were adopted by developed countries, it relates more to the fact that they are somewhat older. And there has been scientific developments in the meantime, other scientific insights. And that may lead to the fact that, yes, there's still this international standard, but listen, we know now better, we know now more, and therefore it's not effective. Right. So this is the relevant law that we have to look at. Now, what were the main panel findings? And mind you, there was no appeal in this case. Actually, there could not have been any appeal. If Malaysia would have appealed, they would have appealed into the void because there was no functioning appellate body anymore. You had a question.
can a country have lenient standards as per the, so you cannot deviate from ISO standard, but can you have lenient standards?
More lenient standards. More lenient standards, unless these standards go in a direction of going against the. You ask a very good question, yeah? Because the more lenient may go to a point where you actually contradict the international standard. Now, is there some room between contradicting and copy-paste? Yes, there is, yeah? So it's a question of, it's a matter of, well, it's something that has to be assessed on a case-by-case basis, yeah? And obviously, on that line, you have to be much closer to really following the, than close to not following it at all. Yeah? But the same goes in the other direction. A more, you say a less lenient will very seldom give rise to straight disputes. It's the stricter that will give, and also there you can be a bit stricter. But not too much strict, because then you actually contradict the international standards. Okay, now, main findings of the panel. First of all, with regard to both of the measures at issue, so both the 7% max and the high ILUC risk biofuel cap and phase out. First question that needed to be answered by the panel, is this a technical regulation? Because the European Union said, we're not very convincing on this, but they made the argument, this is not a technical regulation. The panel said that, and in this they agreed with Malaysia, the arguments made by Malaysia, that the quality of a biofuel being produced or not from feed and food crops is a product characteristic. Whether something is produced with or without feed or food crops is a product characteristic. Now, if you are now thinking, yes, of course, yeah, I agree with you. Yes, of course. Yeah. So this wasn't a very difficult point to win. Yeah. The European Union tried to make an argument that actually the ingredients in the product that were not product characteristics, this was, actually there was case law that already contradicted that. But now we have a clear statement by the panel. And for those that want to work this out and think about it more, every time I added a paragraph number where you can find it. Now, so on that basis, they came to the conclusion that this is a measure that lays down, the measures lay down product characteristics. What is important in this? This was part of the argument, and more realistic argument that the European Union made, at least as from its second written submission. The interesting point is that the panel also said, okay, let me first say what the argument was that the European Union later in its second written submission developed. Well, these measures, they do not prevent the product from being marketed. The product can still be marketed, be it here in a limited number, and under the cap and phase out, well, you can still market the Malaysian biodiesel made with palm oil, but it cannot be counted anymore to the 40% target. That's what it does, this measure. You can still market it. And therefore, since you can market it, it's not a technical regulation. Well, the panel said, and we'll look at the definition of a technical regulation. The definition of a technical regulation is a measure that lays down product characteristics or related ppms. It doesn't say that a technical regulation is a regulation that tells you when you can market something and when you cannot market something. And yeah, this is, and it definitely lays down product characteristics. And see the previous bullet point. So the panel came, that's useful. It's a useful addition to our thinking about technical regulations. This is a technical regulation, even though it does not impose product characteristics and requirements as a condition for placing a product on the market. You can place the product on the market. There are product characteristics, but these product characteristics are not linked to the putting the product on the market. You just have to look at whether the measure lays down product characteristics, regardless of the right to put it on the market. That doesn't count. That is not important in order to decide whether something is a technical regulation. So, final conclusion was that the measures are technical regulations. Now, with regard to Article 2.4, and I'll take them in the reverse order because I'm taking the easier ones first. I'm going to go from easy to difficult to very difficult. Malaysia had argued that there were international standards that the European Union did not follow. They didn't base their technical regulation on these international standards. They were ISO standards, according to Malaysia. And yes, there were standards. They were not very, very focused. These standards often expressed some real doubt about the usefulness of using the concept of ILUC. And the standards actually said that it was not advised to use the concept of ILUC before there were internationally agreed ways, methodologies to establish ILUC, which, as I already indicated, is very difficult. It's not even clear whether it can ever be developed. So there was some expression of doubt in the ISO standards. But and the panel, in its wisdom, said that these ISO standards were not the relevant standards for the problem that we were here confronted with. Because none of these ISO standards, and the next is a quote, precludes a national regulator from addressing ILUC through its own approach outside international standardized methodologies. Now, there were no internationally standardized methodologies yet to establish ILUC, but there was no prohibition on regulators, national regulators, to use ILUC. No prohibition. There was an expression of concern. Don't do it, but there was no prohibition. And therefore, these ISO standards that expressed this concern about ILUC, but didn't prohibit it, were not considered to be relevant standards in this context. And Malaysia was found to have failed to establish that the high ILUC risk biofuel cap and phase out was inconsistent with Article 2.4. Note that this claim of inconsistency with Article 2.4 did not relate to the 7% max. It only related to the cap and phase out measure.